The following content addresses issues of misinformation, misinterpretation of official documents, and the impact of rumor-based narratives online. This video is intended for critical discussion and analysis. This content is not intended to target, harass, or speak negatively about any individual. Please do not contact, harass, or direct hostility toward anyone discussed or implied in this video. I do not condone harassment of any kind and encourage respectful, thoughtful engagement. The intent of this video is to promote transparency and protect my community by encouraging critical thinking and responsible consumption of information. I welcome viewers to share their perspective and thoughts in a respectful and constructive way. All thoughts, feelings, and discussions are encouraged to take place in the comment section of this video. Please show respect when sharing. Thank you.
Welcome back. Throughout this series, I've been talking about our community, why I care about it, why accuracy matters, and why I take the time to really look into the information that gets shared. My goal has been to keep things grounded in facts and to make sure we understand what we're looking at before forming opinions about it. For this final part, I want to focus on one specific document. I'm going to break down exactly what it means or what it could possibly mean. I don't think it breaks open any wild epiphanies about the case. I think it's completely irrelevant. Sorry to interrupt, but it actually turns out that this document is extremely interesting and it's going to open up a lot of questions that you may or may not have already had and some things we've all been wondering about this case all along. But I want to make sure you all know exactly what it really means. And then once this video wraps up, it's going to be the end of this series because I'm working on some documentaries right now. So that being said, thank you for being here. Let's get into it.
Just coast. Just coast.
Just coast. Just coast. Just coast.
Welcome to the show.
The lore of this series, how it began.
This happened on August 19, 2013. This is when Dee Dee wanted to get power of attorney in some way. It doesn't really matter what exactly her intent was, but what we do know, if you look down here, halfway down, it says patient's attorney stated that because patient, who's the patient? Gypsy Rose. Who's attorney? Patient's attorney. Gypsy had an attorney representing her. And as many of you know, when you have an attorney representing you, they have a fiduciary relationship with you. They are taking your needs into consideration, not Dee Dee's, whatever her intention was. So we don't know. This is kind of a standard thing that happens, but because patient had never been deemed incapacitated, she could not move forward with seeking guardianship. So I guess Dee Dee was looking for guardianship over Gypsy. As I said before, I am now becoming to think that Gypsy was abusive towards Dee Dee. I know that for a fact because she shot her. Let's go back to the clip now and hear what Bree and Christy and other people on the panel are alleging.
If you are somebody that was raised by your mom, isolated, alienated from other parents and family members, was never allowed to be alone with anybody, basically like your friends, you don't know what the fuck power of attorney papers is. She knew her mom was trying to get guardianship, which I have those papers too. She got denied that, but she did get the power of attorney. Her having a feeding tube, all Gypsy had to be was not conscious at a point, and there you go, she can make a medical decision.
Incapacitated. Let's get the terminology correct. Not conscious is when you're in surgery.
Incorrect.
If they put you out under anesthesia, right? Dee Dee wouldn't have any power to do anything at that point. Incapacitated. You're in a coma.
Oh.
Incorrect.
You're on death's door. Something like that. At that point, for everybody in the world, you need somebody to make the medical decisions for you. That's all that was.
But Gypsy thought those papers would always, like, she thought that these papers were basically like what you would think, like, what a guardianship papers was. Gypsy didn't know the difference between either one. So
yes, they had to specifically sit Gypsy down and talk to her. That's the social worker's role. That's the attorney's role. But let's think about this logically, okay? Let's think about how this really works in the real world. Dan actually told Gypsy, she talked about how she never felt like she could move out as long as her mom was around. At one point, she mentioned something about a power of attorney. If it was only medical power of attorney, he told her there was nothing to worry about as long as she was 18. So now we've got 3 different entities or people that have informed Gypsy about the power of attorney. You've got the social worker on her case, her own social worker. You have her own attorney, who has a fiduciary relationship with her.
Hi, editing Jesse here. I just realized that throughout this entire video, I keep saying that Gypsy's 19 years old when in fact at the time she was 22 years old. So please keep that in mind as you're watching. I didn't want to have to refilm the whole entire thing. So I apologize. She's not 19, she's 22. Thank you very much. First, I'm going to read the document and then I'm going to explain what it means. Social work progress note entered on August 19th, 2013 at 15:05 hours Central Daylight Time. Progress note. Social work note. SW, social worker, received phone call Friday, August 16th, from PT's mom stating that PT, patient, so we'll just say patient, that patient had been scheduled for a PAT and an H&P on August 21st and dental rehab surgery on August 22nd. Patient's mom stated that she had made an appointment with an attorney to seek guardianship of patient. Social worker contacted Dr. Grau to confirm that she was comfortable continuing with the surgery if guardianship was being sought. Dr. Grau stated that she was, but suggested contacting the OR board runner to determine if anesthesiology would be comfortable. Anesthesiology stated that if guardianship was being sought, they were not comfortable moving forward until that was finalized. Social worker contacted Dr. Grau and Gladys, dental clinic manager. All of them made the decision to cancel surgery. Social worker received phone call from clinic manager stating that patient and patient's mom have drafted a POA. We're going to get into the details, okay? Social worker spoke via telephone with patient's mom and attorney, Sativa Sloan, to clarify information. Patient's attorney stated that because patient had never been deemed incapacitated, she could not move forward with seeking guardianship. Patient's attorney stated that she believes a judge will not authorize guardianship because patient's cognitive delays are not severe enough to warrant it. As such, patient's mom has drafted a POA, power of attorney, but Gypsy Rose will plan to sign consents for herself. Social worker notified clinic manager, who states that she will follow up with Dr. Grau. Social worker notified anesthesiology. Social worker will remain available and will advise patient's mom once lodging arrangements are finalized with Medicaid. Social work, acuity 2, total counseling time, 91 to 105 minutes. Original documenter, Sarah Melias, LMSW, social worker, blah, blah, blah. There's her phone number. And the date and time, August 19th, 2013 at 15:04 hours Central Daylight Time. So what does this note mean? Does it mean Gypsy has an attorney, Gypsy has a lawyer, and that there's a fiduciary obligation? No, it doesn't mean that. So let's talk about what it does mean, okay? This is a hospital social worker progress note. It documents why a scheduled medical procedure was delayed and explains the legal steps that were discussed at the time. The note begins by stating that the patient was scheduled for a pre-admission testing and a history and physical exam, followed by dental surgery the next day. So a PAT and an H&P, followed by dental surgery. Pre-admission testing is the routine medical testing done before a procedure. This can include labs, vitals, and other checks to make sure everything is safe to proceed. So a basic pre-surgery check by a doctor, standard procedure. A history and physical is when a doctor reviews the patient's medical history and performs an exam to confirm they are medically cleared for surgery. So he's going to go over all her history of her medical situation and make sure she doesn't have any contraindications for whatever they got to do for the surgery, probably anesthesia and whatnot. So at this point, the procedure had already been scheduled and was moving forward. The note then explains that the patient's mother told hospital staff that she had an appointment with a lawyer to seek guardianship. Guardianship is a legal process where a judge can give one adult the authority to make decisions for another adult. Once a child turns 18, they're no longer incapacitated. So any child under the age of 18 is already legally incapacitated. That means the parents have to make the decisions for them. That can include medical decisions, financial decisions, and day-to-day matters. It requires a formal legal process and a judge's approval. So, who do we know who's had guardianships? Bam Margera, Britney Spears. We know those two for a fact, okay? So that's guardianship. You don't have to be in a coma to have someone get guardianship over you. What it means is that once it's approved, it's very sketchy in the system because there's a lot of crime that goes along with guardianship because people end up taking over their finances and draining their accounts of all their money. They can legally tell the person that they can't be in a relationship. They can control whether the person gets married or not. They can control all of their money, all of their medical decisions, all of their everything, their housing, their bills. You literally lose complete control over your whole entire life once someone has established guardianship over you. A judge just has to deem you incapacitated. You don't have to be in a specific medical state, like a coma or anything like that. A judge has to be like, okay, I can see why this person needs somebody else to take care of all their decisions, control their whole entire life. After learning that guardianship might be pursued, the social worker contacted the surgeon and the anesthesia department. Hospitals must be certain that the person signing consent forms has the legal authority to do so. Because of that, the procedure was paused until the legal situation was clarified. The note specifically mentions that anesthesia was not comfortable proceeding until that was resolved. That's standard practice because anesthesia involves risk and requires proper consent. Then the note explains something important. It states that the patient had never been legally declared incapacitated. Incapacitated is a legal term. It means a court has determined that a person cannot understand information well enough to make informed decisions or manage their own affairs. That only happens after a legal case, medical evaluations, and a judge's ruling. If that has never happened, then legally the person is considered competent. Competent means the person is legally able to understand information, make decisions, and give consent. So they're 18 and older, and then all those things I just listed. The note then says that any cognitive delays were not severe enough for a judge to approve guardianship. This explains why guardianship was not pursued. Guardianship has a high legal standard, and a court must decide that it's necessary before giving someone else control over another adult's decisions. Instead, the note explains that they chose a different option, power of attorney. Power of attorney, or POA, is a legal document where a person gives someone else permission to act on their behalf in certain situations. The person still keeps their rights. They are still legally competent. They are simply allowing another person to help handle paperwork or decisions. So, we can sit here and speculate about why this was going down. Is Dee Dee really trying to push the fact that Gypsy is in this wheelchair and she needs constant help and monitoring? We don't know exactly why she's doing it, but it kind of opens up a little bit about like what the possibility of what Dee Dee's intent was. It just makes you curious, basically. It just brings up questions. In this case, the note states that the mother would use a power of attorney to sign medical consent forms. Because the legal consent question needed to be sorted out, the surgery was canceled for the time being. The social worker documented that they notified the clinic manager, the surgeon, and the anesthesia team about the delay. The note also mentions that the social worker would help with lodging arrangements through Medicaid. This is a practical support service. When procedures take place away from home, social workers often help coordinate travel and lodging through Medicaid. So since an attorney's name appeared in the note, I wanted to know whether or not Dee Dee had actually retained her as a lawyer. It does mention something about how a POA was drafted in this note. So maybe she went to this person to draft because Sativa Sloan, that's what she does. She's in Springfield, Missouri. She's basically like the top dog. And so she knows that system very well. And she told Dee Dee, she doesn't qualify for guardianship, but I can help you draft up a power of attorney. Now, when I called Sativa Sloan, they weren't allowed to give me any information over the phone. And then I also missed the phone call when she called me back later in the afternoon. But I do have the recording of when I called the first time.
How may I help you?
Yes, may I speak with Sativa Sloan, please?
May I ask who's calling?
Yes, my name is Jessie. And I was just calling to ask her a question about a prior client she may or may not have had in 2013.
Okay. I can take a message for you.
Yes, I'm calling to verify something for research. I'd seen Sativa's name listed on a medical social worker note connected to this client's name, and I just wanted to know if she actually represented them or if she was just only consulted briefly for that situation. Would you like to know the client's name?
Yes.
Okay, it's Claudinia Blanchard and or Gypsy Rose Blanchard.
I can relay the message.
Okay.
But we are not allowed to talk about the client files. I can give her your contact information.
Okay.
What's your name again?
Jessie.
Okay. Name? Okay. And what's the best phone number to reach you? Okay. Great. I will pass this along.
Thank you.
Thank you. Bye.
Bye. What I wanted to ask Sativa Sloan, and what I will hopefully ask her if I can get in contact with her, is that because her name's on this note, does that mean that she was actually retained, or does it mean that she was just giving you the advice for this one specific incident. I can only imagine she would have been expensive. So I'm gonna guess, this isn't fact, but I'm gonna guess that she didn't retain her, but she definitely sought out she chose a very good attorney to get advice for the guardianship. And then I'm sure Sativa can help draft up a POV. But according to all the documents that we've all been researching together, I haven't seen anything that said she ever actually did get power of attorney over her. Do you guys know of that? I don't. I haven't personally seen it. And no, I haven't gotten my FOIA stuff yet. So hopefully, I don't know, I'm getting ready to cancel it because it's like the thrill's kind of gone. But anyway, when you look at this note from beginning to end, it shows a sequence of events. So a surgery was scheduled, a question came up about who could legally sign consent forms, guardianship was considered but not appropriate, power of attorney was used instead, and the procedure was delayed until the consent process was in order. To break this down again, what the document really shows. This note is important because it shows that the patient was not legally incompetent, there was no court-ordered guardianship, the hospital was concerned about legal liability, and they only felt safe proceeding once consent issues were cleaned up. In other words, the system briefly treated this like this person may not be able to legally consent case, but it ended with, they actually can, so guardianship isn't approved. That's what the whole note is no biggie. It's no big deal. Doesn't say Gypsy had an attorney or had fiduciary, blah, blah, blah. It doesn't have to say any of that. Why this kind of note matters. These social work notes are legal records used to show who made decisions, who said what, and why medical care was delayed or changed. They're often used later in court cases, disability disputes, malpractice claims, and media investigations. Hi, editing Jessie here. So as I was editing, I started really thinking about what this all means in regards to this case, right? About all the questions we have about whether or not people believe that Dee Dee did abuse Gypsy or that Gypsy abused Dee Dee. I think that the answer will always be, we do not know the extent of it. We know what we can prove that Gypsy did to Dee Dee in a couple of incidences. We don't know what else she did or didn't do, and we certainly don't know exactly what Dee Dee did. We all only come up with our own hypotheses about that situation. But I started thinking about this social worker note and about what it meant and about the guardianship and about the power of attorney. And now, purely speaking from my own mind, my thoughts are, well, there's lots of questions, but guardianship is very serious. It's very rarely granted in courts. So I started thinking about how originally everyone was like, oh my gosh, poor Gypsy. Dee Dee had Munchausen by proxy and she was making Gypsy suffer. She abused Gypsy. That's medical abuse. That's, psychological and whatever physical kind of abuse because of the wheelchair, yada, yada, right? But in this document, this legal binding document, which Dee Dee is the one who is communicating with the social workers in regards to their life, Gypsy, the situation. So if we think about what all of the misconceptions were about the case in the beginning, about everything I just mentioned, and about how she was lying about Gypsy's age and everything else that falls in place, this document states legally that Dee Dee isn't lying about Gypsy's age. She's making it very clear about how old she is, which is why she had to have gone and legally established guardianship if she wanted to be the one in control of signing the documents. Dee Dee isn't, in this particular situation, Dee Dee is not lying about Gypsy's age. It's very clear that Gypsy is 19. It's very clear that she's old enough to make her own decisions. But for some reason, and we do not know why Dee Dee wanted to have control over this situation or at least be able to sign for her. And I personally think that it's because she has been pushing for so long the fact that Gypsy is mentally handicapped, she has MS, she has all of these health conditions that could essentially make her unable to consent for her own medical procedures. And that's what this document is about. It's about a person who is an adult who should be able to sign their own forms and be able to consent to their own medical treatments and procedures their mother, who is their caretaker, is saying, well, since I legally can't sign for her medical papers anymore because she's an adult, I'm going to have to seek guardianship. So the social worker got in contact with Dee Dee and legally put that on paper because the procedure had to be canceled and rescheduled because of that ongoing procedure of Dee Dee trying to establish guardianship. Once Dee Dee contacted Sativa Sloan and Sativa told her, you're not going to qualify for guardianship because Gypsy is competent enough to make her own decisions and sign her own forms, she's like, okay, well then I'm going to at least draft up a power of attorney so that I can sign for her forms, because to me, theory, personal thoughts, speculation, I think that it's because she was still really trying to tell people that Gypsy was not capable enough to do those things. Now, more questions arise because of that thought. Was Dee Dee feeling that way because she was the one pushing all of this onto hospitals and doctors for so long? Or was Gypsy making Dee Dee think that she was mentally handicapped, had worse ailments than she actually did? I don't know. I don't know. I find it hard to believe that as a mother, your child could convince you of anything. To be honest, your child can't convince you of anything. As a mother, no. Girl, get your ass up and go to school. You know what I'm saying? So what we do know is within this document, Dee Dee was trying to be able to sign for Gypsy because she was at least telling them that she didn't think she was able to do everything on her own. And in this particular situation, someone needed to sign and confirm everything was okay to be able to proceed with this surgery. I find it hard to believe that Gypsy was the one saying, I need this surgery and I need that surgery. So it really leaves a lot of questions on the table about where the actual line is between Dee Dee telling hospitals and doctors that her daughter is sick, for what reason we do not know. We do not know. We will never know. And how much Gypsy was making it either seem like and playing along, or how much Gypsy was convincing Dee Dee that she was more sick than she was. I just find that hard to believe. You just can't like convince your mother that you have things. I mean, maybe, not in my family, but maybe there's mothers out there that are like, oh, you know what I mean? And they'll just, whatever. But it's going pretty far to do what was happening in Gypsy's situation. I think that at this point, this is 2 years before Dee Dee died. This is my own theory. This is my own personal speculation. This is absolutely not a fact. This is my own personal thought. Allegedly, personally, in my own opinion, this is 2 years before Dee Dee died. I mean, obviously she didn't know she was going to die, but has she now finally decided, okay, I'm done with the whole charade? Everyone knows because of this social worker, because of the CPS case, because the social workers came out and did a welfare check on her. Everyone knows how old Gypsy is. She's not as young as the medical paper says she did. The jig is up, right? So the jig is up with the hospitals. It's gone on long enough. Dee Dee doesn't want to get in trouble, potentially, possibly. These are my thoughts. Possibly, maybe Dee Dee doesn't want to get in trouble anymore. Maybe it's getting to the point where it's like, okay, Gypsy's an adult. There is a possibility because she can walk, and I'm sure Dee Dee knew that at this point. Can we at least all agree that Dee Dee knew Gypsy could walk at this point? Gypsy's an adult. She's no longer incapacitated. She can make her own decisions. She can sign for her own medical procedures. She can consent to them. She can handle them on her own if she has to. Everyone knows how old she is because social workers got involved. Hospitals were starting to look at them a little sideways. Doctors were getting a little concerned. And I want to go into that a little bit more. And the way we can go into that is breaking down the CPS thing. I'm not going to read it again. So I asked for a second opinion about the social workers' doctor's note. Not because I didn't explain it clearly. I did. But what I wanted to know was, I just wanted another clear explanation of it. Maybe a different way of breaking it down. Maybe they could clarify some things and specify some details about it. And this is what it said. The document means the patient had upcoming appointments or surgery scheduled. The patient's mom told social work that PAT and H&P were scheduled for 8/21. Dental rehab surgery was scheduled for 8/22. That's August 21st and August 22nd. The mom was considering guardianship. The mom said she had made an appointment with an attorney to pursue guardianship of the patient. Why this matters. If a patient may not be able to consent for themselves, hospitals need either a legal guardian or a clearly valid alternative. Sometimes POA, sometimes that's not enough, before surgery, especially for anesthesia consent. New legal plan. Okay, Dr. Grau decided to cancel the surgery. That's a major action item and is clearly documented, okay? New legal plan. No guardianship. POA was drafted. Later, the social worker received another call from the clinic manager stating the patient and the patient's mom drafted a POA. The social worker then spoke with the mom and the attorney named in the note, the attorney's position. Because the patient had never been deemed incapacitated, the attorney could not move forward with guardianship. The attorney believed a judge would not authorize guardianship because the patient's cognitive delays were not severe enough to justify it. Consent plan going forward. The mom drafted a POA, but the patient will sign surgical consents for herself. The note explicitly says that. So just because Dee Dee drafted a POA doesn't mean that that's how they went on with it. Doesn't mean that Dee Dee became the power of attorney, because it says the patient will sign the surgical consents for herself. Gypsy's just going to sign for her own stuff. She's old enough. She's not incapacitated. So I asked, is there a psychological reason why this whole entire procedure was going on? Why this whole entire thing with the guardianship and the POA and Gypsy just not handling and signing her own paperwork? Is there a psychological reason why the mother would have gone through all of these steps instead of just making it easier and having Gypsy sign them in the first place? Or is this standard operation? And it said, there can be psychological family dynamic reasons a parent might push for guardianship POA around a competent 19-year-old. But there are also a lot of non-psychological practical reasons. A Medicaid, travel, and anesthesia paperwork can make it feel more bureaucratic. What's in your note fits confusion, not my note, but the social worker note that we read, fits confusion plus risk management plus support needs. More than anything, automatically pathological. So it's saying before there's anything like really to be concerned about, like as far as like a psychological or a pathological reason why someone would be doing this, the note is based around the fact that according to all these doctors, surgeons, and anesthesiologists, that there was confusion, risk management, and support needs that need to be handled before the surgery is scheduled. First, is this standard for Medicaid? No, being on Medicaid. Okay, so that's what I asked. Or is it standard for Medicaid? Because obviously Medicaid is being used in this situation because Medicaid's taking care of the lodging and everything. So I said, is this standard for Medicaid? No, being on Medicaid does not by itself require guardianship or POA for surgery. A competent adult on Medicaid can consent for their own care like anyone else. What is common is that Medicaid may involve transportation, lodging coordination. The note mentions lodging arrangements with Medicaid and more back and forth paperwork authorizations. But Medicaid isn't a trigger for guardianship. Capacity over consent is. Practical non-psychological reasons a mother might do this. These are very common and any one of them could apply. 1, the patient has cognitive delays or developmental disability, but still may be competent in everyday life. Families often hear mixed messages over the years. She's fine versus she needs help. And when surgery anesthesia comes up, they fear she won't understand risks well enough. The note specifically mentions cognitive delays, and the attorney felt they weren't severe enough for guardianship. Hospitals sometimes use guardianship loosely when they really mean legal authority or consent clarity. Staff might ask, do you have guardianship, as shorthand for who signs if she can't? Families then think they need to go get guardianship urgently. Anesthesia consent is high stakes and teams are conservative. If anyone suggests the patient may not be able to consent, anesthesia often won't proceed until the decision maker is legally clear, and that is very, very true. Trying to avoid a last-minute cancellation, ironically causing one. Mom may have thought, if there's any doubt, I'll get guardianship so nothing gets delayed. The patient may be competent, but has communication barriers, anxiety, trauma history, or becomes overwhelmed. In real life, some people can technically make decisions but shut down in medical settings. Families anticipate that and try to formalize support. Shit, I'm like the opposite. I'm fine in medical settings and then I just shut down in real life. Maybe I need a guardian. Psychological family dynamic reasons. Possible, not a diagnosis, but these aren't standard practice, but when they happen, these would be some of the psychological reasons behind this. High anxiety or catastrophizing. Surgery feels scary. Legal control reduces mom's anxiety. So maybe they're thinking the kid might pull, or adult child could pull out of it at the last minute because they get anxiety, or they're making a big deal out of it when it's not a big deal. Difficulty tolerating the child's adulthood. Now this I found so interesting, okay? Difficulty tolerating the child's adulthood. Some parents struggle with the transition at 18 and try to keep decision-making centralized. That's interesting, right? Enmeshment or over-involvement. Here's another one. The parent experiences the adult child's health as my responsibility, even when the child could take the lead. So perhaps Dee Dee was feeling like, I'm really starting to get overwhelmed, feeling like even though she's completely competent, I've been having to take care of her medically for a long ass time. Well, I mean, whose fault is that though? You know what I mean? But that's an option. This is not fact. These are just possible options psychologically why this whole entire scenario went down. So again, enmeshment or over-involvement. The parent experiences the adult child's health as my responsibility, even when the child could take the lead. So Dee Dee's thinking like, well, even though she's old enough and she can consent, like I still feel like I need to take care of her. I still feel like I need to be the one to take care of her because, you know, if you want something done right, you got to do it yourself. Or I don't know what a reason would be, but that's a potential possibility. Another one, protective instincts shaped by past crises. If the daughter had medical issues, learning disabilities, or safety incidences growing up, mom's protective role may be deeply ingrained. Less commonly is controlling behavior or secondary gain, either for attention or benefits, but you can't infer that from this note alone. It's common when there's any hint of cognitive disability, communication challenges, or uncertainty about capacity with anesthesia. There could be psychological reasons, anxiety, protectiveness, difficulty with letting go, but nothing in the note proves a pathological motive, okay? So, this second to last sentence really stands out to me. It's common when there's any hint of cognitive disability, communication challenges, or uncertainty about capacity with anesthesia. Think about that statement, okay? So what it tells me personally, what that says to me, we all know Gypsy was completely competent. We all know that she does not have a cognitive disability. I don't care what anybody says. She's very smart. She's been very smart since she was a baby. We've seen little videos of her. She's been extremely intelligent her whole entire life. She's still extremely intelligent. You know, she has mental health issues that she needs to deal with, but she's not stupid. She's not cognitively disabled, and she doesn't have communication challenges. If you found this interesting, put a thumbs up on the video. If you guys have your own theories about it, please leave them in the comments. I would really like to know what you think. That being said, there's another document, okay? It's the CPS visit to their home. I have a whole entire video where I read it. Now, I'm going to explain that to you about what that means. That's the fun of this Gypsy Rose case, right? The fun of the Gypsy Rose case is diving deep into the weeds and trying to come up with our own conclusions because no one will ever know because Gypsy lies and Dee Dee's dead. And it's not fun if someone's only reading portions of it and then really forcing their own opinion down your throat about it. But first, I want to read you a transcript. And yes, this is a Becca Scoops transcript. This is literally word for word, not changed, not altered. This is directly from one of her videos. This is another one of her claims as to why she wants y'all to think that for sure Dee Dee Blanchard was sexually abused. This is, I'm just going to read it to you, okay? So you can hear it out of my mouth. A mouth who you know speaks very clearly and tries to be very clear with the information that I give you. Okay? Here we go. Again, this was literally transcribed from one of her videos, or this is just her reason why she says she thinks Dee Dee was sexually abused. Okay? Word for word, not changing anything. We've got her high school friends talking about how Dee Dee was so sweet and generous and kind person. She was genuinely a very likable person. Even the people in the Missouri community. then D, then Gypsy's born, ill with health concerns. I don't have those records, but obviously because when Dee Dee lived with that, her father, when Gypsy was just an infant after she broke up with Rod, because that breakup happened like at 6 months or 4 months, Gypsy was still not even 1 year old. I'm pretty sure they lived there. And Claude remembers this whatever type of breathe. I don't know if it was a CPAP or what they had on Gypsy at the time that the alarm bells would go off, meaning she had stopped breathing and they would rush in there. And he said it was scary. It was a real memory he had. So then you've got that happening, and then you've got Hurricane Katrina happening, and now she's got nowhere to live. Huh? What? I'm sorry. Repeat that? No, thank you. Can you imagine if this is what y'all are jumping on the truth train? This is why you guys jump on what is wrong with you guys? I'm sorry. Chugga chew, no. Okay? What? And she says it with her whole chest, okay? With her whole entire chest. And then probably follows it up with, okay, this is what you guys need to know. These are the facts. It's like, girl, I mean, I don't know what it is about her that got you all hypnotized. I mean, seriously. There's just so many red flags. But there you go. If I ever start talking about this, I'm probably having a stroke. Y'all need to call 911 and tell them we don't know her name or address or exactly what town she lives in, but she needs help, because I'm probably having a stroke if you ever hear me talk like this.
Pushing facts versus pushing a narrative. What patterns and behavior to be mindful of?
That's why that was it's written in her medical records and in her DFS report. Not only was her mother reported from a hospital to DFS for suspicion of Munchausen by proxy, but 2 different doctors even noted it in her medical records.
There's not 2 different doctors that noted Munchausen by proxy in her medical records. Of course, I don't have all of them. I know of one. I just report the truth here, okay? I've seen one doctor mention it, not 2. The other thing is, one did mention it. 1 out of how many doctors? So that was wrong. Yes, he did come up with it, but where did he get it from? He got it from the internet.
Well, unfortunately, they're both wrong. They're both a little bit, tiny bit right, but they're both very technically wrong. Here's a clip from one of my videos explaining what they're referencing.
2020 did a full investigation of the case and released a documentary called Gypsy's Truth and Lies.
The biggest question was, though, how was Dee Dee able to con the doctors?
Hospitals we contacted declined to comment, but we tracked down one of her former neurologists, Dr. Bernardo Flasterstein.
For my initial assessment, I saw a 14-year-old girl that was sitting in a wheelchair,
who examined her for muscular dystrophy and cerebral palsy and immediately saw red flags.
The testing didn't seem to show the same type of disabilities that Gypsy should be showing.
There was nothing there to support either. It made me very suspicious.
And his suspicion only grew when he told Dee Dee what should have been exciting news. Gypsy's prior diagnoses were wrong.
But the mother was not happy with that. And when she left the office in a storm and told my nurses that I don't know what I'm talking about and that she's not coming back.
Dr. Flasterstein ultimately said, I believe that the mother suffers from Munchausen by proxy. That was one of the things that I believe he bolded and underlined in that letter.
When you have a suspicion and you think that harm has been caused to the child, you could report that to social services and say, I have a suspicion. I, at the time, did not think that I'd had enough information just to call.
Dr. Flasterstein didn't call Child Protective Services, but someone else later did. According to this police report obtained by 2020, a doctor alerted authorities when he could not find any symptoms that support what Dee Dee alleges to be wrong with her daughter. 2 caseworkers later did visit the Blanchard home, but they found nothing out of the ordinary and closed the case.
This is the copy of the report, Check Wellbeing. I just found that very interesting. So my point is that this information is fact. This report really happened with professional people that work for the government, work for the system, work for the courts, work for the government, essentially. And that we can see proof right here that Dee Dee did lie about her daughter. But what we also see is Gypsy not speaking up
not pulling them aside. What we see right here is proof that Dee Dee was lying about her, was trying to convince doctors that she had conditions that she didn't have. Doctors were very concerned, and that Gypsy is playing right along. Gypsy is not reaching out for help. Gypsy is not saying a word. Unbiased and speaking purely from a professional forensic standpoint, the hospital's suspicion would almost certainly fall into this category. Concern for fabricated or exaggerated illness presented by a caregiver. Not a conclusion, a concern. What triggered suspension, objectively? From what I described, or the transcript that I gave it, 3 red flags appeared together. No clinical findings, a physician examined the child and found no symptoms, no objective medical evidence supporting the mother's claims. This alone doesn't prove anything, but it creates medical inconsistency. Number 2, inconsistent personal information. The Missouri Child Abuse Hotline they received stated Gypsy was reported to be 17 or 18 years old, but was actually older than that. Clayton advised that Dee Dee was unable to provide a social security card, birth certificate, or any medical records showing Gypsy's actual medical conditions. This is a major institutional red flag because hospitals rely on continuity of records, inconsistencies interfere with verification, and it suggests either confusion or misrepresentation. From a systems perspective, this undermines credibility of the reported history. Third-party reporting, hospitals to DFS. Hospitals do not contact child protection lightly. They typically do so when a caregiver's claims don't align with medical reality. The situation raises concerns about unnecessary medical intervention or risk to the child. This isn't about guilt, it's about risk assessment. DFS advised that Claudine claims her daughter is paralyzed from the waist down, has MS, cancer, and other medical issues. According to the DFS hotline call, St. John's Hospital contacted DFS and informed them that a doctor has checked on Gypsy and her alleged medical issues that Claudine claims Gypsy has. According to DFS and the hotline call, a doctor could not find any symptoms that would support what Claudine alleges to be wrong with her daughter. Without naming any diagnosis or outcome, the hospital's working suspicion would be that the caregiver's account of the child's medical condition may be inaccurate, exaggerated, or fabricated. This kind of report does not mean the caregiver is lying or malicious or intentionally harming. It means the child's reported condition does not match clinical reality, and the pattern warrants external review. Hospitals are legally required to escalate when subjective claims conflict with objective findings, and the child's welfare could be impacted. Is the child being medically represented in a way that is accurate, safe, and in their best interest? When the answer is unclear and the data is inconsistent, institutions default to protective reporting, not accusation. It's a systems-level response, not a moral judgment. And so then I asked, could that potentially be signs of Munchausen by proxy? And it said yes, that exact pattern is one of the classic reasons clinicians consider Munchausen by proxy, but it's important to be very precise with language. The correct modern term is factitious disorder imposed on another, FDIA, formerly called Munchausen by proxy. And the key word is consider, not diagnose. How hospitals think about this clinically. Hospitals don't jump to Munchausen by proxy. They move through a decision tree. What I described in the transcript hits several screening indicators for FDIA. Reported illness with no clinical findings, caregiver claims serious conditions, doctors find no objective evidence. This is the primary trigger for suspicion. Inconsistent medical history, different birth dates, missing diagnosis, changing details. This is a huge red flag in child safeguarding. It suggests narrative instability or intentional alteration of records or inability to verify claims. Caregiver continues seeking medical validation despite lack of findings. This signals possible over-medicalization, attention seeking via illness, or psychological need for the child to be sick. FDIA is not a crime label or a moral accusation. It is a clinical risk category, meaning a caregiver may be presenting or exaggerating illness in a way that is not supported by medical evidence. The concern is unnecessary procedures, psychological harm, and medical system manipulation. This pattern is not proof of FDIA. It is a sufficient threshold for protective investigation. In practice, hospitals think this might be confusion, this might be anxiety, this might be misunderstanding, but it could also be FDIA, so we must escalate. They report not because they're certain, but because they'd be negligent not to. From a hospital's perspective, the question is never, is this Munchausen by proxy? The question is this child being medically represented in a way that creates risk? According to the hotline, Claudine provided different personal information on Gypsy. Due to the inconsistent birth dates and lack of medical diagnosis, DFS wanted Gypsy checked on to ensure she was not an endangered runaway or missing juvenile. They also wanted to ensure that Claudine was the biological mother to Gypsy. DFS and I made contact with Claudine and Gypsy and spoke to them about the situation. Claudine stated they are from Louisiana and left there during Hurricane Katrina and came to the Springfield, Missouri area. When confronted about all the inconsistent information that she had provided to the hospital, Claudine stated she didn't know why the birth dates and personal information were wrong. FDIA is just one of the recognized risk frameworks that explains this pattern. Bottom line, yes, the situation I described is exactly the type of scenario where FDIA enters the conversation at an institutional level, not as a diagnosis, not as an accusation, but as a child safeguarding hypothesis that must be ruled out. When the hospital calls the DFS hotline, okay, so this was my question. When the hospital calls the DFS hotline, would they ever report to them by using the terms Munchausen by proxy or FDIA, or how would they word their report? The short answer is almost never. They don't call the social workers and tell them, I think that this person has Munchausen by proxy. They don't even put it in their reports like that. They don't do that. They go through a series of steps in order to see if something may lead up to something like this. And at that point, then they will go from there. But it takes a series of investigations, including social worker doing a welfare check first before they can even leap to that. They certainly don't put it in their hospital notes. They may note it in their personal notes, but it's not going to go into a report for social workers unless they've already gone through all the steps, okay? Hospitals typically do not use the term Munchausen by proxy or even FDIA in a hotline call. They describe observable facts, not diagnoses. How hospitals actually word these calls. When a hospital calls a child protection hotline, DFS or CPS or CD, they use language like medical findings are inconsistent with caregiver reports, no objective symptoms observed to support alleged conditions, caregiver continues to report serious medical issues without clinical evidence, concerns regarding medical history reliability, possible medical misrepresentation, concern for unnecessary medical intervention. They stick to what was observed, what was documented, and what could not be verified, not psychological labels. Why they avoid diagnostic terms is because using Munchausen by proxy or FDIA in a report is legally risky. It can prejudice an investigation and it exceeds their role. It implies motive they cannot prove. So institutionally, they never say, we think the mother has FDIA or Munchausen by proxy. They say we are concerned about the accuracy of the caregiver's medical claims and potential risk to the child. The internal versus external language split. Internally, medical chart or case conference, the doctors may privately discuss FDIA or factitious disorder, somatic misrepresentation. But externally, to a hotline or to DFS when they begin this process, they use behavioral and evidentiary language only because DFS and CPS investigates facts, not diagnoses. Typical hotline report structure. A real-world report usually sounds like child presented for evaluation, caregiver reports multiple medical conditions, physician found no objective evidence to support those claims, caregiver provided inconsistent identifying information. Due to concern for medical reliability and potential risk, hospital is making a report, which is exactly what the note said. It's exactly how the hospital reported it to to child services, and that's exactly how that welfare check was initiated. No labels, no theories, just risk indicators. The forensic takeaway, important. If you do see a hotline report that explicitly says Munchausen by proxy or FDIA, that usually means a specialist has already been consulted or a prior investigation exists or it's secondhand wording added later. But first contact reports almost always avoid those terms. Bottom line, hospitals report patterns, not pathology. They don't say, this is FDIA or this is Munchausen by proxy, go check on them. It's not how it works. So no, you're not going to see reports from doctors. You're not going to see it. They may discuss it amongst each other in chit chat, the doctors. They say this situation does not make medical sense and may place the child at risk. And that's exactly how child protection systems prefer it. And I ask, could a licensed caseworker have an idea that those reasonings in the report potentially mean that is what may be happening? Not for the report, but just a mental note not to be used in the case. So I just was asking, like, could a social worker be aware of this type of pathology that exists when they're going out to the house to go do the welfare check? They're not going to mention it, but in their mind, could they already be aware of that when they read, this sort of a report that's been reported to them? And it said, yes, absolutely. And that's actually very normal in child protection work. A licensed caseworker would almost certainly recognize that pattern and make a private mental note that it could be consistent with FDIA or Munchausen by proxy, even if it's never written in the report, never said out loud, or never used formally in the case. How caseworkers are trained to think. Caseworkers are trained in risk frameworks, not diagnoses. So in their head, they're constantly running through categories like medical neglect, emotional abuse, fabricated illness, caregiver anxiety, misrepresentation, over medicalization. FDIA is one of those internal frameworks. It's not a conclusion, it's a pattern recognition tool. The mental process realistically when a caseworker sees repeated medical claims, no objective findings, inconsistent records, caregivers driving the narrative, their internal thought is often, this could be factitious presentation. I need to watch for this pattern. That's not suspicion in a legal sense, that's professional vigilance. What it says private. They don't write it because it's speculative. It can be biased future decisions. It's not something they can prove, and it's outside their role to diagnose. But internally, it absolutely becomes a monitoring lens. They'll subconsciously start paying attention to escalation of symptoms, doctor shopping, inconsistent stories, caregiver behavior versus child behavior, pressure for tests or procedures, not to accuse, but to detect risk early. This is actually considered good practice. In safeguarding professions, this is called hypothesis generation without hypothesis fixation, meaning you generate possible explanations, but you don't commit to any, and you let evidence guide you. A good caseworker always has several mental possible models running in the background. FDIA is just one of them. Bottom line, professionally accurate, yes. A licensed caseworker would very likely think this pattern is consistent with factitious illness by proxy, among other possibilities. They just keep it internal, provisional, and unspoken until and unless real evidence ever supports it. That's not bias, that's competent risk assessment. And then I asked what NCIC is, because in the report it says that Dee Dee said, oh no, I don't have, Gypsy's birth certificate or anything to prove her age or anything like that, which she ultimately ended up having and showing. But before she did that, they ran both of their names in what they said was NCIC. I didn't know what that was. So if you don't either, it's National Crime Information Center. It's a nationwide database run by the FBI that law enforcement uses to share and access criminal justice information in real time. So I started thinking, well, it said what NCIC actually is a secure system that allows authorized agencies all over the United States, it's nationwide, to instantly check criminal histories, outstanding warrants, protection orders, stolen vehicles, missing persons, firearms, wanted persons, identities, and aliases. It's essentially law enforcement's central nervous system. So because in this report, they had mentioned we wanted to see if Dee Dee was her actual mother, because that was one of their concerns, they were probably checking NCIC to see if their names come up as, a flag in the system. What if Gypsy's name came up as a missing person in the system? And so on and so forth. Who can access it? Only police departments, sheriff's offices, federal agencies, courts, limited, and authorized criminal justice personnel. The public cannot access it. Typical uses: when an officer runs your name, runs your license, or runs your plate, they're usually checking NCIC plus state systems. Important forensic detail: NCIC is not just criminal records. It includes civil protection orders, missing children, restraining orders, warrants that aren't convictions, flags like armed and dangerous. So an NCIC hit means there is a law enforcement record associated with this person, not necessarily guilt. In casework investigations, when you see NCIC check completed, NCIC hit, cleared NCIC, it means the person was searched in the national law enforcement databases, and it's often used to verify identity, assess risk, locate people, and confirm legal status. NCIC is not a court record system. It's an operational police intelligence system, so entries can exist if charges were dropped, no conviction happened, and this case is ongoing, which is why NCIC data is not public evidence. Oh, I ask, what does it mean when a person's name is ran and if they don't find any information? Because that's what it said in the report. It said we ran their names through NCIC and we didn't find any information. Not unless steps have already been taken to get to that point where they really feel like that needs to be examined further. In law enforcement terms, when a person's name is run and nothing comes back, it simply means that there is no record of that person in the databases being searched. Nothing more, nothing less. What no record actually means is that the person has never had law enforcement contact. No arrests, no warrants, no protection orders, no missing person reports, no criminal cases entered. So I said, what are the reasons a person may be found in NCIC? Outstanding warrants, protection restraining orders, civil not criminal, but still in NCIC, domestic violence protection orders, restraining orders, no contact orders, even if no crime occurred. Missing person status: if someone is reported as a missing adult, a missing child, endangered person, or a runaway, they are entered into NCIC. And then criminal history identifiers: if someone has ever been arrested or booked, fingerprinted, charged, they'll usually have an identity record. Even if charges were dropped, they were acquitted or the case was dismissed. Domestic violence cases you filed. This one is important. You as the victim, usually no criminal entry. But if a protection order was issued, a restraining order or a no contact order, that order itself does go into NCIC linked to the respondent, the person restrained, and sometimes your name as the protected party. So you may appear in NCIC not as a suspect, but as part of a civil protection order record. So that got me thinking, because in this same report, after further investigation, it was found that Claudine had a bad marriage and got a divorce. Due to her fear of her ex-husband, Claudine had changed her daughter's information at the hospital so that her ex-husband would not be able to find them. Now Dee Dee's telling this DFS worker that she had a bad marriage, that she was in fear of Rod, Gypsy's dad, and that all of a sudden she does remember that she changed the information at the hospital, and it was because she didn't want Gypsy's dad to find them through their medical records. Claudine and Gypsy were checked through Mules and NCIC with negative results. Dee Dee's telling them, oh, the reason that the information's different at the hospital is because I was in a horrible relationship. I had a bad divorce and I was trying to keep us away from my ex. So it's like, well, okay, if it was that serious to where you're changing your identity and your child's information at the hospital so that your ex-husband doesn't find you because it's that bad, you'd think that there would probably be some sort of a restraining order that would have taken place, right? There would have probably been some sort of a protective order, wouldn't you think? I mean, they're just going to leave it up to themselves to safeguard themselves. I'm not saying this is the situation. It's just what got me thinking, right? Because that's her big excuse in this report that we're talking about right now. So I thought, well, nothing came up in NCIC. So that probably was a mental note to the caseworker who was like, okay, well, nothing's coming up. So Gypsy's not missing. There's no protective orders against her from her ex-husband. So let's dive a little deeper. Because if there's no protective order from her ex-husband who she's claiming she's so afraid of, that probably raised some questions. Restraining order / protection order. This does go into NCIC. If a court issues a restraining order, a protection order, a no contact order, any of those would be an NCIC. So it's like, well, how afraid were you really, Dee Dee, of Rod? You know, you didn't even have any of those. You didn't even go to court to get a restraining order. Then that order is entered into NCIC so that any officer anywhere in the US can instantly see that it exists and enforce it. The clean rule situation, you file a DV report, you're not going to be an NCIC. You are the victim, you're not necessarily going to be an NCIC. Someone is arrested, yes, they will. Restraining order issued, yes, they will. A warrant exists, yes, they will. So I hope that that helps clarify some things. The whole social worker dental surgery form was bothering me. This entire situation came down to the difference between what a document actually says and what someone thinks it says. When people rely on that interpretation, instead of taking the time to understand the terms, the context, and the process behind it, the end result is confusion being passed around as truth. You know, if people are going around telling everybody, no, Gypsy definitely had an attorney and that was a financial obligation or whatever she said, and then goes and argues with people, it's just such a waste of time and it's just a negative ripple effect. So don't forget that, you know, when you hear the term incapacitated, when they're referring to like a guardianship or a power of attorney, it just, incapacitated is a legal term that a judge has to give someone. It's only given by a judge. It's a legal term. It's by law, you are incapacitated. Britney Spears and Bam Margera were not in a coma. A judge decided, okay, we'll consider them incapacitated. And then also anyone under the age of 18 is already legally incapacitated. So not every single kid in the world's in a coma. So I want to leave you with one final thought. And, you know, if you don't take the time to understand what the words of documents actually mean, it's very easy to misunderstand what you're looking at. And once something is misunderstood, it can quickly turn into a completely different story when it gets repeated, interpreted, and built on. Not understanding a document isn't the issue by itself. It's nobody knows everything, and we all have to learn as we go. The problem starts when something isn't fully understood, and then assumptions or personal theories get added in and presented to others as if they're confirmed facts. That's where the confusion spreads, and that's where narratives start forming around things that were never actually stated. This series wasn't about attacking anyone. It wasn't about proving anyone right or wrong. It was about slowing down, looking carefully at what's actually written and making sure we understand it before drawing conclusions. Because when we're dealing with real people, real records, and real situations, accuracy matters, okay? And sometimes the most responsible thing we can do is simply take the time to read, learn, and make sure we're getting it right. So with that being said, I hope y'all learned something today. I learned a lot researching this. And now we've got those 2 dang forms down pat. If y'all have any questions, or if you have any fact checking you'd like to do with me, or if you know more about this than I do, please put it in the comments. If you liked this video and you've been watching this whole series, please consider subscribing before you leave. And I hope you have a wonderful day. Take care of yourselves. Oh, I was gonna do the moon reading of the day, but then I was thinking maybe I'll do a whole video about it, because I'm probably going to have to explain it to you guys. It's just not that simple. It's going to be a little complicated for me to explain it. I'll give you the moon thing for the day, and then I'll make another video to explain what it means. So today's February 9th. It's a Monday. The moon is in Scorpio, and it's at the beginning of the 4th phase of the moon. Today was good for pruning for better fruit, mowing your lawn to decrease growth. We're going to talk about that. And that's it for today. But for tomorrow, the 10th, which is very soon, it's a good day to neuter or spay animals, demolition, cut your hair to decrease the growth, harvest or root crops, mow your lawn to decrease growth, prune for better fruit, wean children. And that's all for the 10th. I think I'll have to make a whole entire video about how to explain what all of that means, because it is complicated. It took me a long time to figure out how it all works. But once you understand it, I mean, I couldn't even fully explain it to anybody, but once you learn how to read the charts, it's pretty amazing. So we'll get into that in another video. So take care of yourself. Love yourself, love your neighbors, love your friends, love, love, love. And I'll see you next time.
What about Jesse?
What about Jesse?
Stop playing around with her.
Yeah, what about Jesse, man?
Linebacker Jesse.
Everybody's got their money on Jesse.
Everybody go sub to Jess, man. Get her popping.